I'm delighted to welcome our speaker today for Reproductive Rights Shabbat, Jessie Rossman, who will be speaking about the current state of abortion access. Jessie Rossman has worked at the ACLU of Massachusetts since June 2013 and is the first woman to serve as legal director in the organization's 104-year history. She has extensive trial and appellate advocacy experience in both state and federal courts, litigating on a broad range of civil rights and civil liberties issues, including in the areas of reproductive rights, privacy and technology, access to medication for opioid use disorder, criminal legal reform, and government transparency. Before joining the ACLU of Massachusetts, Rossman served as a law clerk to Judge Raymond C. Fisher of the U.S. Court of Appeals for the Ninth Circuit. She also worked as a staff attorney at the ACLU of Michigan and as a litigation fellow, the Natural Resources Defense Council. Jessie has a law degree from Harvard Law School and a bachelor's degree from Yale University. And Jessie feels a deep connection to Temple Amuna. She is the daughter of Shelley Rossman, founding and long-serving director of our Billy Dalwin preschool, and has many happy memories of the time she spent in our community. Welcome, Jessie.
Shabbat Shalom. I am genuinely so glad to be here with all of you today. It is exactly where I need to be in this moment. Notwithstanding my father lovingly still calling me a young attorney, I've been practicing for some time now. And over the course of those years, my speeches about abortion care have shifted quite significantly in ways that I could not have imagined when I started my legal career. But the thing that hasn't shifted, and this is something that I want to emphasize for all of you here today, is that the vast majority of people in this country support continued access to abortion care. So today, I want to talk to you about where we are, what we're watching for, and most important for our Kehillah, what we can do moving forward. So let's set the stage. For the majority of my life, Roe versus Wade was the law of the land, and that at the federal level created federal constitutional protections for the right to access abortion care. In the summer of 2022, the Dobbs decision reversed Roe. It overturned 49 years of precedent. And there's a whole other speech we can get into in terms of the reasoning or lack thereof that is in the Dobbs decision. But at its bare essence, what the court held was that the due process protections over certain rights that we recognize are protected in the Constitution. Some of them are not expressly enumerated in the Constitution. And what the majority held in Dobbs was that abortion was not one of those rights that were unenumerated, but still protected under our due process clause. And it turned towards a requirement that these rights had to be deeply rooted in our nation's history. In doing so, they were laser focused on the time at the ratification of the 14th Amendment. For those of you keeping track, that was at the end of the 19th century, at a time when women could not vote. The decision is historically inaccurate, it is legally specious, but it became the law of the land, and that left access to abortion care to the states. So that's where I want to start today. What are we seeing right now in the states? Where are we? So in the wake of Dobbs, 12 states issued near total abortion bans. The degrees of the sliver of exceptions for life and health of the mother is varying in degrees, but for all intents and purposes in 12 states, there's a complete ban. That includes Alabama, Arkansas, Idaho, Indiana, Kentucky, Louisiana, Mississippi, Oklahoma, South Dakota, Tennessee, Texas, West Virginia. I think it's important to name the names. If you are going to have a complete ban, you should be named as having as such. There are also 7 additional states that have near complete bans before 18 weeks, very limited. So Florida, Georgia, Iowa, South Carolina, after 6 weeks, there's a near complete ban. Nebraska and North Carolina, after 12 weeks, a near complete ban. And after 18 weeks, Utah has a near complete ban, particularly in those 6 to 12 weeks. As I think I probably don't need to explain to folks in this room, many people do not even know that they are pregnant during those periods of time. So this has had a very significant impact in what we're seeing actually play out on the ground and how it is impacting people's lives. We've seen an increase in travel to states that do not have bans. So in 2020, the Guttmacher Institute, for folks who are interested in data, by the way, I highly recommend you go to the Guttmacher Institute's website. They have fantastic and very up-to-date and in-depth and cited material, which is very important. So according to the Guttmacher Institute, in 2020, 1 in 10 people were traveling out of state in order to access abortion care. By the first half of 2023, so this is right after Dobbs essentially, that number was 1 in 5. And in terms of impact on the ground, I just want to really pause there, because when we're talking about travel, I know for me, I think about travel, I'm like, how often am I jumping on a plane? How often am I leaving the state to do something? But for many people who are trying to access abortion care, and particularly in some of the areas of the country where you need to abortion care, travel is not going to Rhode Island. Travel is traveling hundreds and hundreds of miles. Travel is making sure that you get time off from work. Travel is making sure that you have childcare for the children that you already have, because many people who are accessing abortion care already have families. Travel is making sure that maybe there are other people in your lives you don't want knowing that you're getting abortion care, but if you're gone for 2 days, how are you going to explain that? This has significant impact. When we say travel, I really want folks to feel the weight of that word. We've also seen an increase in medication abortion. By 2023, 63% of all abortions in the United States are by medication abortion. And I hope it goes without saying, but it never should. We were already seeing stark racial disparities in terms of maternal health, and those are only widening with the increase of these bans on abortion care. That's not the whole story, though. In response to Dobbs being passed, access states where there was access to abortion care passed a slew of laws and regulations and public pronouncements in order to continue to protect access to care, not just for people who lived within their borders, but also to ensure that people could come to their state and get access to care. 22 states and Washington, D.C. have passed laws to help provide protections to patients, providers, and helpers. These are sometimes called shield laws. I don't love using that terminology, I'll be honest with you, because what I think these laws are doing, and the best way to describe them is, we are, and I say we because the Commonwealth of Massachusetts, not to toot our own horn, but have the gold standard in this area, are doing everything that we can do to provide protections, but we can't stop what other states are going to do, right? So I always like to make sure that folks hear that, because when you hear of a shield, it sounds like it's all encompassing. It's doing a lot. It's doing everything we can do, and we're going to continue to lean into that, but we can't change what other states are going to do outside of our borders. So as I said, Massachusetts passed what is best in the nation protections and has ended up being copied in a lot of other states. The kinds of protections that we include banning voluntary sharing of information with out-of-state law enforcement with respect to legally protected health care. That term is statutorily defined in Massachusetts to include both reproductive health care and access to gender-affirming care. That was something that was really core to the protections we wanted to make sure was in Massachusetts, and that also has been copied in other states. It also protects licensure of providers who are providing access to abortion care, protects access to medical insurance, and there are a suite of protections to essentially make it more difficult if out-of-state actors are trying to bring suits against individuals who are providing access to care here in Massachusetts. So erecting barriers to getting access to documents via subpoenas, erecting barriers to make it more difficult to get to depose individuals, right? To be able to have those legally binding sort of conversations with them, to protect against out-of-state extradition from hostile states. And in Massachusetts, those protections apply so long as the provider is in Massachusetts and is providing healthcare that would be lawful if it was happening in Massachusetts. And that's important because that means it actually doesn't turn on the location of the patient. If the patient is out of state, the protections I just articulated still apply to them. And 7 other states eventually adopted similar protections regardless of a patient's location. And that includes California, Colorado, Maine, New York, Rhode Island, Vermont, and Washington. As you can hear, New England is holding strong, which I'm pretty proud of. So given the lay of that land on the statutory level, what are we looking for? And one of the things we're really mindful of are challenges to these shield laws. We know that these protections were erected. We know that there are states that are trying to ban access to abortion care for folks who live within their borders, and that's that's leading to a clash. And we actually had anticipated when these shield laws were initially passed that that was going to happen quite quickly. And there was a period of time, it was almost 2 years where that did not happen. But soon after the election, before the inauguration, but after the elections, we knew the new federal administration that was coming in. The Attorney General in Texas filed a civil lawsuit against Dr. Maggie Carpenter. She is a provider in New York. She's been one of the doctors who has been sending via telemedicine medication to individuals who are in banned states. So the civil suit it was not a criminal suit, it was a civil suit. It was brought against Maggie Carpenter. In February, a judge in Texas in that lawsuit fined her $100,000 and enjoined her, ordered her to stop prescribing and sending in medications to Texas. An important point to name here is Dr. Carpenter did not show up for this case. This was in absentia. She did not go to Texas. So there's right now this court order against her. She's obviously not in Texas, she's in New York. So what we anticipate will happen as a next step is that the Attorney General in Texas will likely file a petition in New York State Court to order them, hey, there's this person who's in your border, we have this court order that she needs to pay $100,000, you need to enforce it because she's physically in your state. And if, as anticipated, the New York State Court points to their own shield law to say we're not enforcing this, that's going to set up a legal clash that essentially is then going to go up through the federal courts of how to balance these different states' rights between what is happening in the banned states and these access shield states. There's another case that also involves Dr. Maggie Carpenter that we anticipate will be getting into the federal court system relatively soon. This one is a criminal indictment, and that happened after inauguration. Louisiana, there was a criminal indictment of Dr. Carpenter. It involved another patient who was in Louisiana. And because there's an indictment, they want her to come and show up for a criminal case. Criminal cases you can't do in absentia. And so what typically happens when there's someone out of state that you are requesting to come into your state to face criminal charges is you sign an extradition request. You're requesting the out-of-state governor to send the person into your state. There are certain instances where you are required as a matter of constitutional law to do that. If someone committed a crime in Massachusetts and then ran over the border into Rhode Island, under those circumstances, the Constitution requires that you send the person back. But the vast majority of cases are sort of in a discretionary bucket. They are not that sort of fleeing felon, which is what the constitutional protection is referred to, situation where a governor says, hey, this person actually did a crime in our borders. We would like you to send them over to us. And then it's up to the governor's discretion typically about whether they will comply. Under the shield laws, however, one of the protections was we are not in shield law states going to be complying with extradition requests when it has to do with care that was provided that would have been legal if it was in our state, abortion care or gender affirming care in our state. And so Governor Hochul, and I'm going to read this quote because I couldn't say it better. Governor Hochul's response to the extradition request was, I will never, under any circumstances, turn this doctor over to the state of Louisiana under any extradition request. I will do everything I can to protect this doctor and allow her to continue the work that she's doing that's so essential. So this too is setting up two states that are sort of clashing together, and we anticipate that that's likely going to lead to a federal court case about how this is going to apply. So that's what's kind of on the legal front in terms of the state rights issues that we're talking about, but I really want to focus on the fact that it's not just legal battles. People, voters, outside of courtrooms are really leading the way. And we see that when things have been put to the ballot, abortion access has a resoundingly won. So between June 2022 and November 2023, abortion access was undefeated. There were 7 states where abortion access was on the ballot, and in either by enshrining a right to abortion access in the state constitution, or in a state that was looking to beat back an anti-abortion ballot measure. And all 7 of those states between those 2 years, it won. That was California, Kansas, Kentucky, Michigan, Missouri, Vermont, and Ohio. In November 2024, there were 7 measures that were supporting abortion access that won. That was Arizona, Colorado, Maryland, Missouri, Montana, Nevada, and New York. There were 3 losses in South Dakota, Nebraska, and Florida. I do want to note in Florida, a majority of voters still actually voted in favor of abortion access. They got 57% of the vote, but because it was a constitutional amendment, they needed 60% in order to win. But what I want to focus on is that there were 4 states that President Trump won that also passed abortion access protections. Arizona, Nevada, Missouri, and Montana squarely went in favor of President Trump in terms of the electoral vote and also passed abortion access measures. And I think that sends a very strong mandate to the federal government that a vote for Republican members of the Senate or House of Representatives, a vote for President Trump did not mean that the voters wanted to cut back abortion access. To the contrary, they sent a very strong message that what the people want is to expand access. And that is the mandate the federal government should be governing on. So let's turn to the federal government very briefly. What are we seeing? What are we watching for? I think in terms of what we're seeing come out of the White House thus far, there have been some other executive orders that have come down the pike. There have not been as many yet with respect to abortion access. There were 2 executive orders that came out in the first week that rescinded prior executive orders from President Biden. Those didn't have immediate impact, but they will have potentially knock-on effects in terms of what were the rules and the guidance that had come out of those executive orders from the Biden administration. So that includes clear guidance under EMTALA, which is a federal law that requires the provision of emergency care access when you show up at a hospital. There was very clear guidance from the federal government under the Biden administration that said that emergency care needs to include access to abortion care, even if you are in a banned state. There was also clear guidance where there was a new rule that was passed under HIPAA, which of course are the regulations that govern the privacy of our medical information, that was specifically directed towards not handing over information that had to do with reproductive health care if it was lawful in the state that it was provided. So those are some of the things that might ultimately be impacted by the rollback of those executive orders. It is not self-executing, however, so it's something that we're keeping an eye on. My work doesn't typically involve international work, but I did want to name the funding freeze on foreign assistance here because that has had such a significant impact on people who don't live within this country. So for the last 9 years, Congress has consistently appropriated $607 million annually in foreign aid for family planning. And the Guttmacher Institute estimates that on average, 130,000 women get contraceptive care each day under US funded programs. And as folks who are familiar with contraceptive care, that's something you often need to be getting daily in order for it to work. So the daily impact is enormous on this funding freeze. As on Valentine's Day, on February 14th, the judge issued a temporary restraining order to halt the freeze, sort of freeze the freeze. That's working its way through the courts, but I think it's really important for us to consistently think not just what is the impact that's happening in this country, but this is having significant impacts on, and we know when people don't have access to contraception, healthcare outside of this country, that's not just impacting the person who's not getting access to that care. That's their entire family. That's their entire community. The final item I wanted to name on the federal level is some of you may have heard the word Comstock Act, Comstock Law. I'm seeing nods. I will tell you, like 5 years ago, that's not something you would have seen nods to anywhere, including in any law school classroom. This is an 1873 anti-vice law that banned the mailing of items used to produce abortion. And for decades, courts and Congress have re-ratified this to make clear that that ban only applies to using the mail for unlawful abortion. Not supposed to apply to using the mail for lawful abortions. And that's something that during the Biden administration, the Department of Justice affirmatively took that position in federal court. They issued memos from the Office of Legal Counsel. And one of the things that we're watching very closely right now is to see, is this administration going to misinterpret the Comstock Act and misapply it? That's for advocates in this space, we have a close watch on that. Okay, I'm someone who likes to do things. So I want to talk now very briefly before we close about what we all can do. And from my sort of thinking about this, it's money, mouth, movement. So on the money front, anything that you can do to be supporting abortion funds, it makes an enormous difference. For dollar return on investment, access to abortion care by these abortion funds just makes it a huge difference. There are abortion funds here in Massachusetts, including Emma, Tides for Reproductive Freedom, Abortion Rights Fund of Western Massachusetts. There are also abortion funds that are in banned states that are trying to help people access care from those states. So I think that if you're asking for a place to put your dollars, that's where it should go. In terms of mouth, I clearly, professionally, and also personally, if you know my family at all, I think language matters. I think stories matter. And that can include personal experiences, whether that is your own or close family and friends, or whether it's a value-based conversation. Why you support abortion access. And this is a space where I actually think it's particularly powerful for us to be speaking as a faith-based community, because there are all sorts of voices in the space of access to abortion care. For me personally, I know that my Judaism is directly connected and grounding with respect to the advocacy work that I do on access to abortion care. And sharing that information, I think, may hit at least some people differently than hearing other reasons someone supports access to abortion care. And I think it's really important for us to broaden the narrative. There's so much power in that for people to find common ground, for us to continue to push back against stigma. And that can be, some folks like speaking at rallies, but that's not really the kind of talking that I'm talking about here, although it can be great. And if you're interested, let me know. But it's talking to people you already know, even who support abortion access, but sharing the different reasons that you do so. It's talking to people who are maybe one step outside your circle, neighbors, people who are in your community. Every single conversation that you have helps to reduce stigma, and we know that that is one of the biggest barriers for people being able to get access to care, and that's the thing that is going to change the dialogue, change the needle. The language battle is the battle. I cannot emphasize enough the power in these conversations. Courts and Congress will follow communities. So it's really incumbent on us to continue to put this out in the public sphere and to continue to talk. The last M I want to talk about was movement. And there are lots of different bills, ways to get engaged. I wanted to leave you with something very specific. So at the ACLU of Massachusetts, one of our priority bills this year is the Location Shield Act. And every day, unregulated data brokers right now are buying and selling personal location data from the apps on our cell phones. And we all know the amount of private information that can be revealed from a consistent tracking of your location. That's where you live, where you work, it's where you pray, it's where you access medical care. And the sensitive data has, of course, special salience with respect to access to abortion care. We already know that several companies have been caught selling detailed location data and demographic information about people who have accessed abortion clinics and other medical providers, including 600 Planned Parenthood locations, including in Massachusetts and in 47 other states. So the LSA will do something about that. The Location Shield Act will do something about that. It prohibits companies from selling, leasing, trading, or renting location data. It requires companies to obtain consent before collecting or processing location data. And it will allow companies to collect and process those data with consent for legitimate purposes. And that includes responding to emergencies or complying with state and federal law. We know there's broad support for this in Massachusetts. 92% of Massachusetts voters support passing a law to prohibit the sale of personal location data. One of the things that you can do is make your voices heard in the Massachusetts State House. I know senators that represent Lexington are Senators Cindy Friedman and Michael Barrett, Representative Michelle Ciccolo and Ken Gordon also represent Lexington. I know there are sheets outside that after Shabbos, if you want to go online, you can access our action team and an action item, and we have everything set up to be sending emails directly after Shabbos to your elected officials and asking them to support the Location Shield Act. There are also other opportunities to then continue to do action items with the ACLU, both in a voluntary capacity or email action alerts. But I personally know that I find it really helpful to have like a specific, this is a thing you can do after Havdalah, this is it. So when Dobbs came out, I spoke with my grandmother, Phyllis Rossman, in New York. And the first thing she said was, this decision is wrong. And the second thing she said is, what can I do to help? And to me, this was such a perfect example of how I believe that we practice Judaism in the world. It's what my grandparents and my parents taught me and modeled for me. We call out injustice, we name it out loud, and we act. And that's what we need to do right now. Thank you.
Fisher Koch, Jessie. Reproductive Rights Shabbat is sponsored by Temple Amuna's Reproductive Rights Committee in conjunction with the National Council of Jewish Women. And the committee coordinating this Shabbat program was Susan Mayer, Anna Narenberg, who are co-chairs, along with Margot Zellermeyer and Catherine Kirstein. The committee would like to thank Dawn Moore, Beth Whitman, Ravital Celine, Arlene Chase, members of the Temple Amuna board, and myself for their assistance. The chair of Amuna's Reproductive Rights Committee is Jenny Smirnova. Anyone interested in joining the committee can contact Jenny, Anna, or Susan. And in addition to Jessie's recommendations for action, there are handouts available with information about numerous organizations supporting reproductive rights, which you'll find on a table in the social hall exit near the name tags outside the sanctuary. So please take them home and get involved.